Good afternoon. We'll give it a few minutes for people to come in from the waiting room. Okay, we'll get started. So good afternoon. Welcome to the fall U of M HRPP seminar series, all about research-informed consent. So the HRPP here at University of Michigan and its units host this seminar biannually or twice a year on topics related to human subjects research. And so the HRPP includes two IRB offices, IRB Med and IRB HSBS. The IRB Med office serves as the medical school and hospital system IRB, and IRB HSBS reviews research for all three campuses, including Ann Arbor, Flint, and Dearborn. And so this seminar is provided to you by the U of M HRPP. So our panel today includes Kendra Cooper, who is the IRB Med Director, Christine Paulson, who is the IRB Med Education Coordinator. Andrea Jenkins will join us from the Office of Research Compliance Review, or ORCR, and she's a Senior Research Compliance Associate. I am Renitra Reynolds. I am the HRPP Education and Policy Coordinator. And then Adam Mrdrinovich will moderate the Q&A, and he is a Research Compliance Specialist Lead, Board Member, and Education Coordinator for IRB HSBS. So our topics today will include this brief introduction by myself, and then I'll do an overview of informed consent requirements to give context to the additional presentations. Kendra will talk about capacity for consent and decision impairment. Christine will talk about deviations involving informed consent and how to report those to the IRB. Andrea will give us a presentation on common informed consent documentation mistakes and how to avoid those. She'll provide some best practices. And then I'll round out the presentation with a talk just highlighting some of the consent templates that are provided by both IRB offices and some resources with hyperlinks. And to that end, the slides will be shared after the presentation, and we are recording the seminar, and we will post this on the HRPP YouTube website next week. Additional housekeeping before I get started. The Q&A is open. We will have the Q&A session at the end, but please feel free to input any of your questions into the Q&A box as the panelists speak. If there's an important question that we need to stop someone to answer, we will do that. Otherwise, we'll hold all questions to the end. And so, like I said, I'll provide a brief overview of informed consent requirements. So the requirement for informed consent for human participant research comes from the principle of respect for persons from the Belmont Report, which is respecting individual autonomy and making sure that we provide information needed for decision making to those individuals being recruited or asked to participate in research. The informed consent process is usually documented, commonly by the signature of the participant and sometimes by a legally authorized representative. And as I mentioned, Andrea will go into detail about documentation of consent and best practices for that. The process for informed consent is usually aided by a written document that might be in paper, it could be digital, and researchers also use other tools for delivering information to potential participants. That could be the use of video, question and answer tools to gauge comprehension of the information. And ultimately, the consent process is an ongoing conversation between the study team and potential and enrolled participants where questions should be encouraged. The key components of informed consent from the federal regulation requires that the consent include a statement that the study involves research, describes the study purpose and the procedures or activities included in the research, the expected duration, and identification of any procedures in the research that would be experimental. There should be an explanation of any known foreseeable risks or discomforts, a description of potential benefits to the participant or others, and if applicable, any information about alternative treatment or the treatment that would be available in case of injury. The consent should describe the confidentiality of identifiable data and how it will be maintained, and explicitly state that participation is voluntary. And finally, the consent should include contact information for research questions, so contact information for the PI or a study team member, contact information so that participants can ask about their rights as a human research participant, so information to contact the IRB or the institution that is conducting the research, and information for how to report a research-related injury. There are some additional elements of informed consent that may be required, such as when the research involves unforeseeable risks to the participant or an embryo or fetus if the participant were pregnant or were to become pregnant. Circumstances under which participation may be terminated by the PI. So in other words, participants should understand if there were reasons that they could be removed from the study without their consent, usually for their safety or due to noncompliance with the study activities, but they should know that ahead of participating in the project. Any additional costs associated with participation, the consequences of withdrawing, if they were to withdraw from the study before their participation is ended, so that there could be orderly termination of their participation. For example, they may need to taper off a study drug, and the approximate number of participants. There should be a statement whether significant new findings will be shared, if applicable, and whether or not there's any potential commercial profit from the use of biospecimens and whether participants will share in that profit. A statement whether clinically relevant results, including any individual results, will be shared during the conduct of the during the ongoing project. And then finally, whether research will or might include whole genome sequencing if there's biospecimens being collected as part of the research. So those are the required elements in the regulations. And we all know additionally that there is now a key information section required for the informed consent as well. And this is from the IRB HSBS website. And so the key element or key information section should include a statement that the project is research and participation is voluntary, a summary of the research, including a shorter version perhaps of the purpose, the duration, and a list of procedures, the reasonable foreseeable risks or discomforts, reasonable expected benefits, and alternative procedures or course of treatment, if any. So the key information section is another tool for researchers to have that initial conversation with potential participants, because it summarizes those key elements that might be spread out across multiple pages in the informed consent document into a shorter version. And it's a tool for participants for reviewing once they've enrolled and want to review the key elements of the study they're participating in. So it's important to spend adequate time crafting this key information section in the consent so that it serves its intended purpose of providing key information up front, and someone is able to decide if they are interested in hearing more about the study. Some considerations for the consent process include assessing who will obtain consent. So the study team should be identifying the persons who are qualified to obtain consent, And ultimately, the PI is going to be responsible for making sure those designated to obtain consent have been appropriately trained on the study protocol and the consent process requirements. There should be consideration to a person's ability to provide informed consent. And as I mentioned, Kendra, who will follow my presentation, is going to talk about decision capacity. And so a potential participant should be able to understand the information that's being provided to them as part of the consent process, or they should have a legally authorized representative who could decide about participating on their behalf. And the person deciding whether to participate or not must be able to make the decision voluntarily and free from coercion. There should be consideration to the timing that the consent process will take place. And any agreement to participation must occur before any study activity. Sometimes obtaining information without informed consent, for example, for screening purposes, may be approved by the IRB. And then finally, we've mentioned already that the ongoing process is a key consideration. So built into study visits and interactions with participants, the study team should be able to address questions regarding participation, and they should encourage questions. And encourage people to voice any concerns. And then ultimately, if participants need to be informed of changes in the study procedures, or for example, new risks or new alternatives to participation, those changes and sharing that information with participants are great opportunities to review their understanding of the overall study and for questions to be asked. Participants should understand that they are able to withdraw from the study for any reason at any time, and that's a part of that ongoing progress. And so with that overview, we'll now go to Kendra and the discussion on consent capacity.
All right. Hello, everyone. Thank you for joining us this afternoon. I am going to share my screen here. Why does this always happen to me, Renitra? What am I doing wrong?
I can see your title slide.
Right, but not the, hold on.
And it's full screen for me.
Aha, so hopefully we've gotten there. All right, thank you for your patience. And thank you, Renitra, for the invitation to join everyone today. As Renitra told you, my name is Kendra Cooper. I'm the director of IRB Med. I am a regulatory attorney and bioethicist by training. I just passed my 1-year anniversary here at the University of Michigan as the IRB Med director. Prior to coming to Michigan, I was the director of the IRB at Creighton University in Omaha, Nebraska. Prior to that, I chaired for Advara IRB, and I started my IRB career as in-house regulatory counsel for Quorum IRB. But I'm very happy to be here at Michigan and to be joining you today. So let's talk about research with adults who lack cognitive capacity. What I hope to share with you in the next 15 minutes or so is a discussion in which we will begin by talking about consent capacity, what we mean by that, and the implications of that. We'll talk about the regulatory obligations shared by the IRB and investigators anytime we have research enrolling this population. We'll talk about the relevant ethical principles that guide research with this population, some of which Renitra has already introduced. We'll talk about what we know from federal regulators, what they have shared with the IRB and investigators via guidance about some of the things we should think about when we are conducting research with this population. And then we'll wrap up with a discussion of IRB Med policy relative to research involving adults who lack consent capacity and some recent changes we made to our operations manual about research enrolling this population. And then we'll wrap up with some key takeaways. So consent capacity. When we're talking about consent capacity, we are talking about somebody's ability to understand the information that has been presented to them about the nature of the research, such that they are able to both weigh risks and benefits and reach an informed decision about participation. Consent capacity also involves the ability of the subject or the participant to communicate their decision clearly to researchers and others. So when I talk about this with researchers, one of the things I emphasize about consent capacity is we can think about maybe the difference between a little yes and a big yes. A little yes, would you like a cup of coffee? Yeah, maybe, sure. Coffee sounds good. Thank you. But when we're talking about consent to participation in research, it is a big yes. It is a full, reasoned, contemplated, weighed decision that is communicated back with certainty. The other thing we know about consent capacity, in addition to that big yes status, is that consent capacity is not binary. It is not the case that adults either have consent capacity or don't have consent capacity. In this way, when we talk about research with this population, there's a fundamental difference than when the IRB and the researcher and researchers are enrolling members of other vulnerable populations. For example, whether or not you have a subject who has the legal status of being a minor is binary. They're either a minor under the law or they're not. A subject is either pregnant or not, or imprisoned or not. But when we're talking about consent capacity, we are talking about something that fluctuates. It's not as tidy and easy to pin down. In fact, in assessing consent capacity, sometimes we might feel like we're trying to pin algae to the wall a little bit. It shapes, it shifts, it moves. It can manifest, as adults, we can lack consent capacity temporarily. For example, the one too many margaritas hypothetical, or you've just been in a car accident and hit your head. Those sorts of things could lead to a temporary loss of consent capacity. We also have do research with populations who have a more permanent impairment. So that all of that is part and parcel of what makes doing research with this population potentially complicated. So what are our regulatory obligations when we are doing research with this population? Both OHARP and FDA have codified in the relative regulations the obligations of the IRB to take additional measures when reviewing research enrolling adults who lack consent capacity. They do so, however, using a little bit different language. In the common rule, the IRB and researchers are directed to take specific additional measures when we are enrolling individuals with impaired decision-making capacity. The FDA regs, on the other hand, speak to mentally disabled persons. In either case, what both sets of regulations are speaking to is an individual who either temporarily or more permanently cannot get to that status of reaching the big yes. Anytime we are doing research with this population, the IRB and researchers have certain ethical considerations that they also need to be aware of. Renita already introduced some of these, and I'm sure everyone on this webinar this afternoon are aware of the Belmont principles: autonomy, beneficence, and justice. When we talk about autonomy, what we're really talking about is voluntary participation, including the ability to consent to participation. Under the principle of autonomy, we are also told to ensure that where we have a subject who lacks consent capacity, we appropriately seek consent, surrogate consent, via an LAR. So when I think about autonomy, rather than voluntary participation or merely voluntary participation, as if that is a mere thing. What I think about is the principle of autonomy really obligates the IRB and researchers to meet subjects where they are. That means subjects who have full consent capacity, we fully honor their informed decision about whether or not to participate. And where subjects lack full consent capacity, we ensure that surrogate consent is provided by a suitable individual. The IRB and researchers also have beneficence and justice concerns anytime we're talking about research involving this population. With the principle of beneficence, for example, the IRB and researchers should be careful to ensure that we are avoiding harms that might be posed or would be posed if we enrolled individuals in research through which they were exposed to unjustifiable risks, right? That's the flip side of do good is do no harm. Under justice considerations, there are a pair of things that IRBs and researchers need to be aware of. The first is that we don't want any members of any given population to unjustly or unfairly, disproportionately bear the burden of research risks and research-related harms if that population is not going to directly benefit from that research. Certainly everyone on the webinar today is familiar with the legacy of research abuses that gave rise to the National Research Act, the Common Rule, and the myriad of frameworks under which we work now. Unfortunately, that history includes performing research on adults who lack consent capacity, where those individuals were not likely to benefit from that research. There's a flip side to the justice obligation, however, which is that just because an adult lacks full consent capacity, we don't want to unjustly limit their ability to participation in research, particularly when the research holds out the prospect of direct benefit. So, to recap, we have regulatory obligations, we have ethical considerations, and then we've been given a little bit more information from regulators in the form of guidance about how to begin thinking about operationalizing those regulatory and ethical obligations. So this is the next two slides includes some points that are delivered to IRBs and investigators via FDA guidance. OHARP has not formally harmonized with this guidance, but they also have not objected to the guidance. So in terms of thinking about protections for subjects, adult subjects who lack consent capacity, it is perfectly acceptable, regardless of whether the research is FDA regulated or not, for researchers and the IRB to consider the following points. The first is that PIs should have a method for accurately assessing the consent capacity of prospective subjects. Today, we have a number of validated instruments that can be used by PIs to assess the consent capacity of subjects. And by and large, the IRB trusts researchers to do this ethically and appropriately. Where researchers seek to enroll members of this population, however, they should make sure that their protocols include information for the IRB to better understand how consent capacity will be assessed. And again, the goal here is that we are appropriately enrolling individuals who have the ability to get to the big yes. Other factors or other things that FDA directs us to look at is whether a waiting period would be an appropriate protective measure, giving subjects time to reflect about their decision to participate. We're also told that investigators can use methods to enhance consent capacity. For example, by simplifying the information provided to participants, by involving a trusted advocate or family member to help explain, or from refraining from discussions during periods of heightened impairment. FDA also asked the IRB to consider and investigators to implement reassessments of cognitive capacity throughout a subject's participation in a trial, particularly when you are dealing with a circumstance or a population where consent capacity is likely to be malleable over the course of the trial. So if you are enrolling individuals, for example, with mild cognitive impairment who have full consent capacity at the outset of the trial, but you're proposing a 7-year study, it's possible that subjects may lose consent capacity during that period, and your protocol may need to include measures for how and when you are going to reassess the capacity of subjects along the way. Other things that we're told to look out for, whether or not the research looks to an appropriate legally authorized representative, and whether it's possible for subjects who are not capable of getting to the big yes are nevertheless capable of getting to a small yes. By that, I mean assent. So it is appropriate, for example, if we have subjects who lack full consent capacity, to nevertheless honor a subject's decision about assent, meaning whether even in the face of their inability to get to big yes, what do they feel and think about participation in the study? These are things that we should honor. Other measures to be taken into consideration when enrolling this population, emphasizing the voluntary nature of research and the ability of subjects to withdraw at any time. And then, of course, determining whether the IRB or a third party should observe the consent process as an additional measure of protection. Other things that the IRB is going to look out for when these protocols come across our desks. We're going to look at whether enrollment of this population is reasonable in light of whether there are standard of care alternatives available, such that research may not be appropriate, or a research alternative may not be as appropriate. Absolutely, the IRB is going to look to whether there is the prospect of direct benefit for these subjects, again, hearkening back to that justice consideration and the desire not to exclude subjects when the participation or when the prospect of direct benefit is available. Where there is no prospect of direct benefit, the IRB is told to look at whether the research is of the type that is likely to yield generalizable knowledge about individuals who have the subject's condition or disorder. Other things we're told in guidance, typically for minimal risk research, participation of adults lacking consent capacity should generally be approved, assuming that the research meets the other standards for approvability. After all, this is minimal risk, which means that these individuals, although impaired to some degree, are not exposed to additional risk as a result of participation in the research beyond which they would encounter in their day-to-day life. We are told via guidance that typically enrollment of these subjects in phase 1 healthy studies, on the other hand, the far other extreme, if you will, of the continuum from minimal risk on the one hand and first in human on the other, where risks are not entirely known or appreciated, typically enrollment of adults lacking consent capacity, not appropriate in those phase 1 first in healthy studies. Enrollment of this population, however, may be appropriate in early phase or even first in human studies where there is the prospect of direct benefit and there is not a good standard of care alternative treatment available to individuals with the disease or condition under study. Finally, because we've talked about how consent capacity can wax and wane, another consideration that should be undertaken by both the IRB and investigators is the duration of the study and how many tests and intervention subjects will need to undergo as a part of the study procedures. Again, a long, complicated study with a study population that is likely to lose consent capacity or lose and regain consent capacity may not be entirely appropriate or may need to be adjusted in light of the malleable nature of the subject population. So all of that said, what does IRB Med policy direct the Michigan IRBs or the Michigan biomedical IRBs and researchers to do when we are enrolling subjects who lack or may lack consent capacity? The screen in front of you now, I understand these are text heavy. That's the downside of having to listen to an attorney. We really love words. But this is a relevant section of our OM, and spoiler alert, the change to the OM that we recently implemented is on the screen in bold. The operations manual at IRB Med, consistent with the regulatory obligations and ethical and guidance considerations that we've just discussed, directs that IRBs must review protocols that describe any additional safeguards that are planned to ensure the protection of these subjects. The OM then goes on to list requirements of the IRB. What the OM did not make clear, however, or entirely clear prior to this last revision, is that the additional requirements imposed by the OM only apply where subjects lack decisional capacity. The way that the OM was written before, it looked like even where researchers were clearly enrolling subjects who possessed consent capacity, some of these considerations had to be brought to bear if there was any hint of decisional impairment in the subject population. And there again, we potentially run the risk of running afoul of that justice consideration. If an individual has some form of cognitive impairment, but can still get to the big yes, it is not appropriate for the IRB to impose additional requirements, because an adult who has decisional capacity is an adult who has decisional capacity, just like me, just like you on the call. So we made a revision to our OM to clarify that, for example, individuals with mild cognitive impairment, if they are able to get to a big yes, the IRB does not need to undergo the additional steps that are set out for us in policy. That said, when we have a study enrolling subjects who cannot get to the big yes and who do lack appropriate decisional capacity, the IRB has to take certain things into consideration. And the nature of the things that the IRB takes into consideration depends on two things in particular. The first is the relevant risk associated with the research. We've talked a little bit about this already. For research involving no more than minimal risk, the IRB must find and document that adequate provisions have been made for soliciting assent, and, if required or appropriate, that an LAR is used to provide surrogate consent. But this is a pretty low barrier, and we've already talked about why. When we get to a place where we're talking about the enrollment of adults with impaired decisional capacity and the research is greater than minimal risk, then the other factor the IRB looks to comes into play, and that, of course, is the prospect of direct benefit. Thus, at the University of Michigan, research coming before the IRB Med, if that research is greater than minimal risk and presents the prospect of direct benefit to those subjects, the IRB makes the following determinations. We must determine that the intervention or procedure does in fact hold out the prospect of direct benefit. We must determine that risks are justified in relation to that anticipated benefit, and that the relation of the anticipated risks and benefit is at least as favorable to subjects enrolling in the trial as could be made available to them through standard of care alternatives. Where, as you might expect or suspect, the work of the IRB reaches its zenith is when we are presented with research that is greater than minimal risk and lacks the prospect of direct benefit to subjects. When this is the scenario with which we are faced as the IRB, we have to take even more steps than we've taken at the two sort of levels of research below. Specifically, under the IRB Med policies, we can only approve this type of research if the research presents only a minor increase over minimal risk, and the research presents a reasonable opportunity to better understand or alleviate or prevent the problem affecting the adults with decisional impairment who are being enrolled. Critically, the second step when we are in greater than minimal risk land without direct benefit is the IRB is required to specifically engage in consultation with an IRB member who is an expert in assessing and treating individuals who lack consent capacity. So, as a researcher, you should know that when you submit your proposal to the IRB to conduct research with this population, that we are assessing your research using a matrix wherein we look at the level of risk, the prospect of direct benefit to the individuals, the ability of the research to yield generalizable knowledge that would benefit individuals who lack consent capacity. And then finally, in places where we have greater than minimal risk, no prospect of benefit, you should expect that your research will be exposed to additional appropriate scrutiny in the form of an experienced board member who will be assigned to assess your research protocol specifically for the appropriateness of the inclusion of this population. So what are our key takeaways? First, as we've already discussed, consent capacity, unlike pregnancy, the status of being a minor or a prisoner, is not binary. It waxes, it wanes, and it poses, therefore, additional challenges to both the IRB and to the research community. Second, the IRB must balance ethical considerations anytime a study asks to enroll this population, and in fact, that this population triggers additional concerns pertaining to all three Belmont principles: autonomy, beneficence, and justice. And third, that IRB Med will always be required to follow the three-part finding, or that three-part analytical process that's set out by our operations manual when it comes to research enrolling this population. And that is my last slide. I know we are leaving questions to the end, so I will give this back to you, Renitra.
Thank you, Kendra. Now we'll be joined by Christine Paulson, the education coordinator from IRB Med, for her presentation on deviations involving consent.
Hello, everyone. Just give me a minute to set up. Hello, my name is Christine Paulson, and as the IRB Med Education Coordinator, one of my tasks is to provide retraining for researchers and study teams whose study conduct has met the definition of noncompliance through review and further institutional investigation. It is my hope that the information provided in this session will provide and assist PIs and study teams with the understanding and the importance of properly performing the informed consent process. So I will briefly review the origins of informed consent and applicable regulations. Then I will go and define major and minor deviations and how these definitions relate to informed consent, and I'll give some examples of each type. Then I will discuss how major and minor deviations can fit the definition of noncompliance, serious noncompliance, or even continuing noncompliance, as stated in the HRPP operations manual. And then I will provide actual examples of noncompliance concerning informed consent that have occurred here at the University of Michigan. We've already gone over the Belmont Report principle of respect for persons. But you can kind of think that that is the heart of this presentation. Research subjects have the right to this information so that they can make that informed decision, and researchers must respect that right and perform the informed consent process properly. And it is a process. It starts with the very first conversation. It includes choosing an appropriate setting for the discussions, but also who will attend the discussions and the timing of the discussions. I mean, Consider this. Should you approach someone about participating in your study the same day that that person was informed they have an incurable illness or life-threatening condition? Now, a good informed consent process allows for questions and discussion with others. Afterwards, potential subjects must be afforded sufficient time to absorb and appreciate the information without feeling rushed or coerced. There is no time frame here. The process should take as long as a participant needs to fully understand the research and decide whether or not to participate. And that time can range from minutes to hours, depending on the complexity of the research. Obtaining that subject signature is only one step in the informed consent process. And finally, understand that informed consent is an ongoing process throughout the study, especially if reconsent is required. Now, why is informed consent important? Well, our federal regulations require it, but it's also the ethical thing to do. Now, why is providing a copy of informed consent important? Subjects can refer back to that document as a reminder on the purpose of the study procedures, the risks, and whom to contact, and that they can quit at any time without penalty. Now, the document is part of the ongoing consent process before and after signing. And when it comes to vulnerable populations, the document helps counter subjects' vulnerability by allowing for review by others and allowing time to reflect. Now, reconsent is part of the process. Although in some instances new information may appear within a memo or letter, most often you're going to formally amend the consent document, submitting it to
I think we lost audio from Christine. Okay, she might be having some technical difficulty. Andrea, do you want to go next, or we can see if she can log back in to finish her presentation? I think you're on mute as a
Okay, I think everyone is viewing my slides as of now.
yes, thank you so much.
Perfect. Okay. Today I wanted to go ahead and talk about some common informed documentation mistakes. I'm Andrea Jenkins from the Office of Compliance Research, and I wanted to tell you I have been in many of your shoes. I have been both a coordinator where I have consented participants. I have been a project manager where I've written the consent form. I used to work for a large pharmaceutical company where I monitored, and now I audit on behalf of ORCR. So I have done all of the steps of the consent process. I think most importantly, I have been a research participant myself, so I have signed consent. I would also like to say I signed consent and then was providing written assent for one of my children where I signed incorrectly, wrote the wrong date. So I've seen all sorts of documentation errors from every different aspect. So here we go. Here, my slide's not advancing. One second here, I'm so sorry. Oh, yeah, for some reason. Okay, there we go. You should be cooking. So the outline today is to tell you a little bit about the Office of Research Compliance Review, who we are, and where we are getting the information, and the common mistakes that we're seeing is through my group and what we frequently see. I'm also going to describe informed consent documentation. So as Christine was saying before, we all know that consent is not just a signature, it's the process. And in looking at the informed consent documentation, we want to know, was the process done, and show me the proof of that. We're also going to review unique consent circumstances, such as the assent, e-consent, a waiver of documentation. We're going to discuss common consent errors and observations. I'm going to show you some real life examples of that. And then we're also going to highlight resources on our ORCR website and ways to help you limit and mitigate some of those common observations. So a little bit about ORCR. We're a mighty team of 6. We sit within the HRPP. We were established a little over 20 years ago, and we're here to collaborate with researchers to ensure that U of M is conducting research according to your IRB approval regulations, that you're getting the data that you want and looking for, and we're all doing it to the best of our ability in compliance. So some of our key responsibilities in ORCR is we conduct compliance reviews, and this consists of routine reviews and for-cause reviews. And then we also provide these study consults. These are actually study startup consultations, which I'll touch on at the end. It's a way for you to meet with our team where we can help you review your study before you kick off, and we can talk to you about a lot of common errors we see and how to sidestep those for your specific protocol. So what I'm drawing on today is from our compliance reviews, typically our routine reviews. During our routine reviews, we do study documentation review. This slide talks about all the different review that we do, but what I'm drawing on from today is our subject informed consent review, where we look at the completed informed consent documents. We also look at documentation of the informed consent, re-consent if required. Again, this is the process, so not just the consent document. Do you have any other written documentation, electronic documentation that the process actually occurred? We do this to ensure study teams are consenting according to their protocol, their IRB approval, and that the informed consent document is kind of the proof that the consent process took place. And this can be done whether it's paper or electronic. So I wanted to go over some of our common e-consent platforms that we see used here. Our 2 most common platforms that we see when we're conducting our reviews are SignNow and REDCap. Both of these have become much more common since the COVID-19 pandemic. Study teams are using these. I think they're great. There are a few drawbacks and things I just wanted to highlight that you should know before you use them. First of all, SignNow is not a database repository. So make sure that once a participant has signed consent, your study team has helped them complete it, that you are downloading the consent form from SignNow and filing it away in research records. We often see that pulled down and put into a Dropbox where all of the study consent forms are stored. SignNow has an issue sometimes where consent forms are versioned over, meaning that if I, as a participant, were to sign on Monday and a new consent became available today, it would version over with that new consent form and look as though on Monday I signed a consent form that wasn't even available until today. So don't use SignNow as a data repository. Also, REDCap is available, another great option. Make sure your full document is uploaded to these platforms. A lot of times we see study coordinators copy and pasting paragraphs into REDCap. Sometimes sections are left out. We frequently see that sometimes what participants enter, whether it be the date, their name, isn't the correct information. So we always recommend to study teams that you go in as the document has been signed. You usually get a notification. Sometimes you're on the phone with a participant while this is being done, that you're looking and verifying, did they enter their full name or did they enter a nickname that won't match their records later? Did they enter the correct date? Next is waiver of informed consent. So a couple of reminders about this. An IRB may waive the requirement for elements of informed consent under specific circumstances, such as research that is no more than minimal risk to the subjects. The research could not be carried out practicably without the waiver or alteration, and that the waiver or alteration will not adversely affect the rights and welfare of the subjects. So here, the first thing is the waiver waives the requirement to document informed consent, which means typically that you don't need to obtain a signature. The other most important part here is that the consent process should still be documented in the research record. So a lot of times we see a waiver of consent documentation. We come in and they say, oh, we've consented everyone. Everyone was, read the consent or they saw it in REDCap or whatever the case is. And we always say, show me that they were given it. How would we know that? So that can look like something built into REDCap where you would check that, yes, you went over this with them. The date that it was gone over, we don't need to see their signature, but we need to know that it happened. Participants should still be provided with a copy of the consent if they wish to have it. Some people say no thanks. Sometimes you can email it to them. And the way that you would request this is study teams do this through a documentation waiver in response to item 10.1 in the e-research application. All right, so as Christine mentioned, informed consent is a process. And we always say, if it's not documented, it didn't happen. So show me the documentation. Study teams will often tell me there's absolutely no way we moved forward without consenting them. I'm like, great, let's get those records out. Let's look at it. Is there a note in my chart? Do you have a checklist somewhere? Where is the actual document? So the actual signing of the consent form typically looks like the participant will read through and sign and date their signature, providing that they have, or I should say, stating that they have read, been given time to answer questions, ask questions. And then there's typically boxes that are checked for optional items, such as video recording, audio recording, photography. These are typically opt-in, opt-out, sharing identifiable information for future research, being contacted for participation in future research, and participating in an optional sub-study. Then typically the PI or designee signs and dates, if applicable. Not all consent forms have this as a requirement on their consent document, but if it's there, it needs to be completed. And something to keep in mind, anytime there's these optional boxes or additional boxes for your consent form, it's an additional time to introduce human error. So making sure that you're taking the time to review this with participants. Next is study team documentation review. A couple of key reminders. You want to ensure the informed consent document is complete. That seems like the easy part, but when you are busy and have a next step to get to, or the first part of your visit, or somebody else, there's a scheduled appointment, it's easy to rush through this. A best practice is to write a research note or complete a checklist. Oftentimes, study teams will write this into their protocol or e-research application stating, in addition to signing the consent form, a research note will be written to document consent form. And if that is written into your protocol or application, it's no longer a best practice, it's a requirement. And then here, have another study team member review the documentation. So typically what I used to do when I was consenting participants, I would consent them, they'd be given a copy, we would be moving on to getting ready to do our first part of whatever that visit was, and I would hand the consent to another research team member to say, can you look at it? Typically the person not consenting can see the errors a lot more clearly than you. For U of M investigators and research teams, that might also mean logging into the eResearch application to make sure they have the correct version of the consent, making sure there's no blanks, and if the participant is still there, getting those errors and corrections done while they're still in person for the visit. Or if you've noticed it via electronic, that you've reached back out to them, hey, we need you to update this, we've noticed an error, or making some sort of documentation that you've noted that. One of the things I want to call out with regards to writing a research note or completing a checklist, sometimes we see study team members, well-intentioned, write a research note that looks something like, I met with the participant, I answered their questions, they had ample time to review, they signed and dated. And then they will copy and paste that into my chart or somewhere else in their research records for all 50 participants. It looks really inauthentic, and I almost would recommend not using something that's not written for each participant. It doesn't have to be elaborate, but even saying, this participant had no question, or the participant was there with their spouse, or participant asked about the sub-study, something to note that it was actually specific to that participant's research process. All right, the fun part. Into my examples. So here's a very common example. This one jumps out. It's glaringly obvious. Here, the participant forgot to date their signature. Typically, at a research visit, people have a lot of forms to fill out, or there's been a pre-screening, or they've answered a lot of questions to even get to the consent process. So it's easy for them to say, oh, yep, I signed, and they've moved on. This is an easy one to catch, but making sure that you're getting the date that the process was actually completed. My next example, oh, it looks great. Julie printed her name, she signed, she dated. We are missing the IRB watermark. Again, this is frequently forgotten when the e-consent platforms are used. It's easy to scan a document in or copy and paste and not include that. Then it's hard to verify, was the right version being used at the time this person was consented? Is there a newer version that was should have been used? And then you're kind of going back and verifying documents next to each other to make sure all elements were included in that person's consent version. Okay. My third example, we see this where people will say, oh, it looks like Julie didn't check yes or no for the optional consent. What we would expect to see is no, I do not agree to be video recorded. Great, no problem. You don't need to sign and date for that. But a lot of times we'll find stuff like this, and a research team will say, oh, we decided we're not doing any more videotape for the rest of or videotaping for the rest of the study. In that case, the study team would need to submit an amendment to the IRB, change your protocol, change your consent form, as I'm sure it references video recording, have those elements removed, and have a new consent form version issued. Here we go. Example number 4. So there's actually 2 things on here. The first is the name of the study team member obtaining consent is not here. Who met with them? Again, a lot of times study teams will tell me, oh, so-and-so consents everyone for this study. And especially when there's not the counter box, the counter signature box for the PI or designee, I won't know who that person was. And again, always show us who was there and available for that process. Down here also, this participant, it appears to have signed with the wrong year, perhaps maybe date of birth. I see this a lot of times if somebody's in more of a clinic or medical setting where they've perhaps had to write their date of birth on other forms. So just double checking those for accuracy. Okay. Next, we have this, oh, somebody's super excited to be in your research study. They'll pretty much sign whatever you put in front of them. So they've rushed through and they've checked both boxes, they've signed and dated. What happens here is because they have checked yes and no, in the IRB's eyes, they consider this then a no response. So the appropriate thing here would to be ask the participant to line through an initial and date. And then typically what I used to do then is write a note somewhere below that saying, you know, Andrea Jenkins is the coordinator, talked to Jade, he verified, yes, he did want to be video recorded, made an administrative error, and something there to acknowledge, oh, a mistake was made. This participant does want to be video recorded, or whatever the case is. Next, with the PI or designee, we're about to come into this situation here in January. Whenever we have a year change, it takes all of us a little bit of time to remember to make that update. We've written 25 for so long. We're going to be writing 26. So here in this case, it looks like the participant signed in January of 21, and the investigator accidentally wrote January of 2020. Okay. So here's an example of the assent form. This is typically used for individuals 12 to 17. On this, we would typically expect to see the yes box checked, then the child's printing, signing, dating, and providing their age. And the thing to keep in mind here is, again, a lot of times we see both the boxes checked. People aren't pausing to read very clearly and see what's being asked of them. Another thing to keep in mind with consent documentation and the process when it comes to assent, if a participant signing this is 17 years old, what happens if your study is more than 1 day? It's a year long. This participant turns the age of majority, which in Michigan is 18. So what does that mean? What does your e-research application say? Do they now need to sign consent on a different form instead of providing assent? Here's another example. This is a different assent checkbox. It says the following should be completed by the study team member conducting the assent process if the child agrees to be in the study. Unfortunately, we see all 3 of these boxes checked. However, the first one says the child is capable of reading. The next box says the child is not capable of reading. And then the last one is the child had ample opportunity to have his or her questions answered. From our perspective, obviously, we would hope to see the box checked for it. The child is capable of reading and understanding, and then the child had ample opportunity to have his or her questions answered. Again, people are well-intentioned and just busy and get busy by accidentally checking all of the boxes, and then it looks like, well, were they capable of reading? Did they understand what they were getting into? So just taking the time and making sure that that's completed. Also, again, if somebody is maybe 7 to 11 and they've signed one assent form, if they turn 12, does your IRB application say they need to sign a different assent form should they have that next birthday during the course of your study? So those are some of my common examples that we see of documentation errors. I want to talk a little bit about some of the ORCR self-assessment tools. These are available on the ORCR website for you all at any time. There's a lot of checklists, customizable templates. I always say if you haven't created one already for some of these areas, please use what we have, tweak and customize to your research study. These are designed to help you all, and there's about 12 current topics on there. The 2 I would recommend you focus on based on our talk today. There's one to help you review your informed consent documentation, and one to help you document the informed consent process. So even if the consent document is already signed, there's more to document about the process again. Were they there alone? Did they ask any questions? Anything that's notable about that conversation. The last thing I want to recommend is our study startup consult. So as this states here, we typically send out notices for these. We invite research teams after they've received IRB approval, typically before any subjects have been enrolled. Although if you're early in your enrollment, 2, 3, 4, we would still like to meet with you and see if there's any errors or anything tips and tricks we can point you towards before you really get enrolled, 50 people into it. We typically offer this to investigator-initiated studies, although that's not a limitation. It's voluntary, so if you get an invite from us saying, hey, we're offering this study startup consult, you're welcome to take us up on it. You're not required. Typically, the coordinator or project manager attend. Sometimes PIs join, but again, they are not required to. And if you have a study and you haven't received a study startup notification from our group, on our website is the study startup consultation section. There's this request a consult button where you click on that. You enter what your HUME is. There's a couple of pieces and it lets you, information. Then it lets you request a time to meet with one of either myself or one of my colleagues. And this is where we go over your whole study, but we will also touch on your consent process. What does your application say? What does your protocol say? What do your documents look like? If they're in REDCap already, does it include all of the elements, and how we can help you ensure that this process is documented appropriately. That's all I have for you today. Here is our group's email. And then when you get these slides, this hyperlink will take you to our website where you can see some of those self-assessment tools I referenced. Thank you.
Thanks, Andrea. So Christine had a small power outage, but she's back. So Christine, if you could get your slides back up, and we'll just pick up where you dropped off.
Well, yes, I'm back, everybody, and it is a presenter's nightmare to have the electricity in their office go out, even for a moment, because it completely threw me out. So let me continue on. I'm going to go into now the deviations that we commonly see regarding informed consent, and I need to clarify that the deviation examples I will be providing involve the informed consent process and not necessarily the informed consent document itself. Some of them do pertain to the document, but they're still related to the process. Now, first, the responsibilities of the study team. Investigators and research staff are responsible for reporting the information to the IRB. This means submitting the reports according to the required timelines, adhering to reporting guidance, and this includes the reporting of major and minor deviations. Failure to follow these requirements may result in disciplinary actions, restrictions to research privileges, and reporting of noncompliance to government agencies and or the study sponsor. Now, a general definition of a minor deviation is a deviation from the IRB approved protocol. The regulations are policies, but it does not have a major impact on the subject's rights, safety, or well-being, nor does it affect the completeness or the reliability of the study data. It does not constitute noncompliance necessarily unless, and this is a big unless, it recurs after a researcher has been notified that it is a concern. Now, minor deviations are to be collected during the reporting interval, placed in an aggregate log, and at the time of the next scheduled continuing review, that log is reviewed by the PI, signed, and then the signed log is uploaded in section 4.1 of the continuing review. Now, I'm going to go over some examples, but I really need to stress the word likely. I think Andrea will agree with me. A lot of it depends on the exact details of what happened. So these are likely to be minor. They could be major, depending, but these are more likely to be minor. Using an outdated consent form with minor non-substantive changes that did not impact participant safety or data integrity. The investigator who conducts and signs the form is not on the delegation log, but is listed in the application in eResearch to be on the study team. The written date is not legible, and the signature is not legible. This is minor if the printed name is legible. Now, major deviations, general. A major deviation is also a deviation from the IRB approved protocol, regulations, and university policies. However, they are a significant departure that has the potential for major impact on the subject's rights, safety, and well-being, or affects the completeness or reliability of the study data, and they may constitute serious noncompliance. Now, the study team is to report major deviations within 7 days as an OREO. Now, again, here comes the word likely. These are likely to be major, Most of them are, I would say, definitely major. But first, failure to obtain consent or obtaining consent after the research procedures have already started. Use of invalid or unapproved consent forms. Now, this could be where the consent form used is not a version that was ever approved by the IRB, or that version has expired. Or it could be the consent document used is an outdated version and does not contain the updated risks and study procedures from the current update. Also, a copy of the consent form is not given to the participant. Someone other than the subject dates the form. Or it could be a general improper documentation or process. This could be where the consent form is missing the subject's signature and the investigator's signature and or the parental signature, as Andrea showed you in some of her examples. In research involving minors capable of assent, failing to obtain their assent as required by the protocol. Or it could be where the PI signs the document prior to the subject signing the document. Also, a person who conducts the informed consent is not listed on the study team in the approved e-research study application. And this is a major deviation whether or not the person is listed in the delegation log. They need to be in e-research. Also, failure to reconsent according to the approved plan in section 1.5 of the amendment cover sheet. Informed consent source documents are not available to indicate the subject parent voluntarily agreed to participate and understood the risks. Again, this is repeating several things that Andrea has said. The informed consent process was conducted, let's say, in a busy clinic waiting area. Now, see, that is potential for a breach of confidentiality. Or if the subject's name is not printed on the line provided. And the deviation severity for that depends on the legibility of the signature. Now, and Andrea went over this, but let's say that the optional decisions are left blank in a informed consent document. In that case, the study team must interpret that as the subject does not agree to the option. It doesn't matter. Well, when I talked to them, they said that they would be interested. They just forgot to indicate. It doesn't matter. It's blank. And the blank option is a minor deviation unless, this is a big unless, as you can see, it's in all caps, the option activities were performed despite the option left blank in the informed consent document. Then it would definitely be a major deviation. Now I'm going to finish my little portion of today's seminar with non-compliance related to informed consent. Now, technically, major and minor deviations are a form of non-compliance because they both represent a departure from the study's approved plan. Now, broadly, compliance is adhering to governing regulations, including federal, state, local laws, as well as institutional policies and IRB determinations. Protocol deviations are specific events that break that rule and must be managed and reported. Now, the difference between the two is often in the severity or the frequency of the event. Now, according to our operations manual, non-compliance is defined as the failure of a person or organization to act in accordance with the requirements of law, regulation, policy, requirements, and or the determinations of the IRB. Serious noncompliance materially increases the risk or causes substantive harm to research participants or compromises the rights or welfare of participants, including harm to participant, exposure to a significant risk, compromise privacy and confidentiality, willful or knowing research or misconduct, violation of ethical principles, or damage caused to the scientific integrity of the data collected. Now, continuing noncompliance, This is when noncompliance recurs after a researcher has been notified of a similar or related noncompliance concern pertaining to one or more of the protocols. Now, when can informed consent major deviations become noncompliance or fit the definition of noncompliance? When it poses a significant risk to participant safety, rights, or welfare, or, and this is important, when it is part of a pattern and or suggesting a systemic problem in study conduct that potentially places subjects or others at a greater risk of harm than was previously known or recognized. And yes, this does include minor deviations. Now, a single deviation may not be deemed noncompliance, but if it's a significant deviation, it will likely trigger an investigation and require a formal report to regulatory bodies as well as corrective action. Now, again, continuing noncompliance is when noncompliance recurs after the researcher has been notified of a similar or related noncompliance. An example of this would be continuing failure to perform part of the informed consent process. Now, when it comes to reporting noncompliance, in federally overseen research, it must be reported to the IRB. Now, if the noncompliance in federally overseen research is officially deemed serious or continuing after review and institutional investigation, then it must be reported to the appropriate federal agency, OREP or FDA, according to university and institutional policies. Now, how is noncompliance determined? First, reports or concerns of potential noncompliance are reviewed to the responsible IRB, the IRB Med compliance staff, and our IRB director. Then it can be referred to the IRB chairs for a root cause analysis to determine whether the complaint or allegation of noncompliance is serious and constitutes, again, harm to participants, exposure to a significant risk, compromised privacy and confidentiality, willful or knowing research misconduct, a violation of ethical principles, or damage caused to the scientific integrity of the data collected. Now, it is very important for you to understand that the IRB chair's determination of noncompliance is not made lightly. They take this very seriously. After a review by several parties, a thorough investigation by the IRB chairs is conducted to understand why the deviations occurred. They want to see if they can pinpoint the root cause. Is it human error, unclear procedures, insufficient training, or is it possible to be a willing or knowing misconduct on the part of the researcher? Now, again, as education coordinator, I have provided retraining over the years to concerning noncompliance for researchers and study teams. And I have listed here several of the informed consent noncompliance relating to these specific trainings. And here they are. Each bullet is a different example. Multiple instances of not reconsenting to an updated version according to the reconsenting plans and amendments. Multiple instances of initially consenting a new subject to a study using an outdated version of the document, missing parent signatures on consent forms, late signatures from the person obtaining consent, using outdated consent forms, missing signed consent and assent forms, and an unknown person signing an assent form. Another one where there was no IRB review or approval of their consent revisions, no informed consent was obtained or a waiver from the IRB, no HIPAA authorization or a waiver was secured prior to conducting the research. And then The last example that's actually happened here is oral consent was not documented, written assent was not obtained, outdated versions used to obtain parental permission for multiple subjects. Again, I'm hoping that by providing this information, this may help prevent non-compliance in the future. And thank you very much. I will give it back to Renitra.
Thank you, Christine, and thank you to all the other panelists. So I just wanted to sort of round out this discussion to highlight some of the consent templates and resources that are available from both IRBs within the HRPP. And as mentioned prior, the slides will be available, and so any hyperlinks you'll be able to access these resources. So some available U of M informed consent and assent templates. It's best practice to, or required in many cases, to use the templates provided by the IRB. And on the left is a list of the templates available on the IRB HSPS website. They have one for biospecimens, exempt, a general informed consent, two specific consent templates for the use of a Dearborn subject pool, one for general consent, one for exempt. There's one for data protection the GDPR informed consent template, 3 versions of a child assent for different age groups, parental permission, and then 2, a general and exempt consent for using the intro psych subject pool. And then IRB Med also has standard template and a number of specialty templates available. At the bottom of this slide is the link to the IRB HSBS Informed Consent Guidelines and Templates page where you can find their templates. And then the IRB Med Informed Consent and Assent template page includes a link to the Research A to Z page, which houses all of the templates. But both IRB HSBS and IRB Med includes guidance documents on obtaining consent and assent on their relative pages. And so on the IRB HSBS pages, you'll find information about conducting the informed consent process, information about willing participation and how to gauge that, waiver guidelines, key information elements, which I showed on an earlier slide, general information and tips for preparing the consent document, and that includes assessing the reading level, some writing tips for the consent document, and formatting the document for uploading into eResearch, and then how to make changes to your consent document when there's an amendment or changes required. And likewise, the IRB Med also includes many guidances on informed consent, children in research and assent guidance, seeking reconsent and when that's required, how to go about it when it may not be required, consent accommodation for when there are communication barriers, information about waivers under OHRP, FDA, and HIPAA regulations. There's a link to a plain language medical dictionary if you need to translate some of your scientific language into plain language for the consent document. Guidance on informed consent procedures using electronic systems and remote use of paper documents, and then also how to stack documents in eResearch. And I'll also say that both offices offer education opportunities. So there might be courses on writing informed consent or consent documents. So if you go to the education page for each respective IRB, you can find other educational opportunities, whether it's a live course. And there's also UMICs, which is the university's short recorded videos on topics related to human subjects research. And there's quite a few of those related to informed consent, electronic informed consent, again, writing informed consent documents, assent, and FDA provisions for exception from informed consent are all available as UMIC topics. And then finally, there's some federal informed consent guidance links available here. I want to give a big plug to the informed consent frequently asked questions on the OHRP website. A lot of staff will refer to these frequently asked questions because they are very clear and broken out into specific questions, clear explanations of um, what's acceptable and what considerations need to be given to certain situations involving consent and dissent and parental permission. And there's quite a few on that page. OHRP also has a number of recorded training videos related to informed consent. There's at least 3 that you can watch and even share with potential participants. They have a participant-centered informed consent training, also available on the OHRP website. And then again, as mentioned before, there's an FDA provision for emergency research with exception from informed consent. And so there's a link to that FDA guidance on here as well. And then before we go to Q&A, I also want to thank the HRPP Seminar Series Working Group. That includes Stephanie Leland, also from ORCR, so she works with Andrea, Jennifer Gallen and Nitya Chandran from IRB Med, along with Christine Polson, also from IRB Med. And then from IRB HSBS, Adam Mrjenovich and LeVar Green Jackson, they're all a part of the HRPP Seminar Series Working Group. So I want to give them a huge thank you. And a thank you to all of our panelists. I think this has been a lot of useful information, and hopefully the recording and the slides will serve as a resource going forward to our audience. And then one last plug for the HRPP newsletter, which is called the HRPP Pulse. This went out this week. The November issue went out on November 19th. If you are on a study team member on an active U of M study, you should receive that newsletter. Also, a lot of our support units that support research at the university are also included on receiving that newsletter. If it's buried in your email, we have an archive of every previous version of the newsletter available on the website. And all of the information that needs to be announced from the IRBs, from ORCR, helpful tips and links to guidance are included in that HRPP newsletter. And so with that, we'll go to a few of the questions that we have. And I'll turn it over to Adam to help moderate those questions. And I just want to thank everyone for participating and being here. And if you have any questions after this seminar is over, please feel free to reach out.
Thanks, Renitra. Thanks, everybody, for your excellent presentations, and thanks to the working group. So we do have a few questions. One is a reminder from one of our colleagues that there are specific guidelines for projects that collect biospecimens, and there's guidance on the HRPP website. And Renitra or I will get the link to you so that you can access those if you do that kind of work. So thank you for that. One question, I think this could be for anybody, Renitra, but if a subject withdrew consent that they provided for participation in the study, should this be reported via an OREO in eResearch? And if you're not familiar with that acronym, it doesn't refer to the cookie. It's an other reportable information or occurrence. It's a report type or an application type in eResearch. Who'd like to answer that?
I can. That's okay.
Please.
A lot of it depends on the reason for withdrawing. If a subject is withdrawing due to an issue, a complaint, an accident, or possibly an adverse event, then that needs to be reported through an OREO. But if it's simply that the subject just doesn't want to participate anymore, they're not feeling well, they're tired, they just don't want to participate, that type of withdrawal is usually listed in the continuing review in Section 2.
Excellent. Thank you, Christine. Another question. I think this one is also for you, Christine.
I know, the first one, yes. A lot of that depends on the legibility of the printed name. It does come into question if you can't discern what is being written, especially if you can't tell what is being printed. So that could be a deviation in that instance.
Renitra, can you remind me, can everybody see the Q&A or only us?
I think the audience can see the answered questions, but any of the ones that are open, so like the one that Christine just answered, people may not know the original question, but it was about
Oh,
legibility of the signature.
I'll repeat the question.
Okay, thanks.
This is from Lark at the IRB. The signature is not legible is a deviation, Christine says. Aren't signatures often not legible? This is true, but this is calls to the importance of that printed name line. So as that was what Lark wanted to know.
Excellent. Um, let's see. Another one, if a study would like to use electronic consent, how do you recommend storing the signed consent document?
This is Andrea. I'd be happy to answer. One of the most frequently used repositories is Dropbox. So typically we'll see study teams will pull the electronic consent, let's say out of SignNow, and store them all in Dropbox or another platform for whatever that research study has decided to use, whether it be SharePoint or another storage facility, but typically it's Dropbox. I would say 90% of the studies I review use that.
Great. Christine, Lark has a follow-up question.
Yes, she said that I stated, and again, that particular question was made to me by the data auditors from OCTSU. And I conferred with a lot of the full board team leads, and this is what they said, that is, when it says often, again, as I tried to say in my presentation, a lot of it depends on the actual details. So this would be a difference of opinion.
That was actually the last one, so thank you so much for your questions and your answers. And with that, I'll turn it back over to you, Renitra.
Okay, we'll end this seminar, and when you close your browser, you might see a survey where we are seeking feedback for future topics for seminar series, and we really appreciate any input that you can provide. That survey will also be sent out next week if you're unable to complete it today. And I'll be sending out a copy of the slides and a link to the video on our HRPP YouTube website next week as well. Thank you for joining and have a good rest of your afternoon.